Do not sign a football contract until you have read and understood the dispute resolution clause in that contract. Do not sign a football contract until you've read and understood the dispute resolution clause in that football contract. It's even better if a football contract does not have a dispute resolution clause. Be careful when you sign a football contract, or be mindful of football contracts or employment contracts in football or transfer agreements in football that confer exclusive jurisdiction on the Court of Arbitration for Sports in matters in which the Football Tribunal of FIFA has jurisdiction. You have to be very careful. Sometimes clubs use this dispute resolution clause to frustrate the other party. It's even worse if the clause provides for a 3-member panel at the Court of Arbitration for Sports. You're probably wondering, the CAS has the Football Legal Aid Fund for parties without sufficient financial means to prosecute their football arbitration before the CAS. So you feel unperturbed because you hope to benefit from this legal aid fund, or because you hope the legal aid fund will help you fund your arbitration in the event a dispute arises in your agreement with the club. So you feel unperturbed. You will be hurt. You should be worried, because these clubs can actually frustrate you and make it difficult, if not impossible, for you to benefit from such legal aid fund. And they can achieve this by a simple contractual provision. So here's the gist. The club inserts an innocuous dispute resolution clause in their transfer agreement with your club. In the dispute resolution clause, parties agree to confer exclusive jurisdiction on a 3-member panel of the Court of Arbitration for Sport. Parties sign this transfer agreement. There are payment obligations in the transfer agreement. The club defaults in its payment obligation. You write the necessary demand letter. The club persists in their default. You approach the Football Tribunal of FIFA to file a claim. The club challenges the jurisdiction of the Football Tribunal, citing the dispute resolution clause where parties agree to confer jurisdiction on the CAS. FIFA then declines jurisdiction. You approach the CAS to file a fresh claim. At the CAS, you apply for football legal aid after establishing that you do not have the sufficient financial means to prosecute the arbitration. The matter commences before the CAS. You are happy. Who wouldn't? And then the CAS invites the respondent to pay its own share of advance of costs. The respondent declines. It is a strategy. You know what will happen? The CAS will throw away your application for football legal aid, because parties agreed to a 3-member panel, but the respondent failed to pay its own share of advance of cost. At this point, it will be practically impossible or difficult for you to recover whichever amount that is due under that transfer agreement without going through the difficult process of raising thousands of Swiss francs for the prosecution of this arbitration.